Good afternoon. This is Joe Forward, legal writer for the State Bar of Wisconsin. And this afternoon, I'm here with Jeffrey Spitzer-Reznick. He's currently at Systems Change Consulting, where he advises and does advocacy work in the area of children with disabilities and other areas. And today he's going to talk to us about education law and some of the issues that may be coming up as we get closer to the school year and many school districts contemplate whether they're going online or in person. And I want to mention that Jeff has the State Bar of Wisconsin Pinnacle program coming up on the topic starting on August 25th. Jeff, how you doing today?
I'm doing pretty good, all things considered.
So Jeff, tell us a little bit about what your work at Systems Change Consulting.
Sure. For the past 8 years, it's my firm. And as you mentioned, I do consulting and training like this around mostly education law and rights, mostly of children with disabilities. I sometimes branch out into some other areas. I've been a civil rights lawyer for 35 years, so I certainly branch out into other areas of civil rights as well. And I also do direct representation as well, mostly of children with disabilities and of course their parents, usually in school. But I also do some other school-related things that don't involve children with disabilities, for example, school discipline, and then again, some other civil rights things that may not involve people with disabilities.
Okay. So as we move closer to the school year, and districts are deciding whether they're going to be have virtual learning platforms and be just completely virtual or in person. What are some of the legal issues that you anticipate are going to be coming up as school districts make those decisions?
Sure. Well, my main focus as an attorney has been on children with disabilities. Of course, as a general caring member of the public, there is the overall concern around the health and safety of everyone, children, teachers, administrators, janitors, everybody in the school building. And of course, what happens when those people all go home, right? And so, and as we see, school districts and school boards and administrators are, grappling with that, not just here in Wisconsin, but all over the country. DPI came out in June with an 87-page document called Education Forward, and I had a piece in the Wisconsin Examiner that frankly was pretty critical of that so-called, that's my word, guidance, they call it guidance, to school districts. And actually, I decided to write the article after talking with a colleague of mine who we've actually had many cases against each other. She represents many, many school districts for many years. We get along professionally just fine. And she knew this was coming, and she was concerned accurately that DPI's guidance would be what it turned out to be, which is 87 pages of, here's a smorgasbord of what you could do, school districts, with literally zero directives. There is zero directives coming from the state as to what school districts should do. So now every single school district, over 420 of them, from the smallest one building school districts to Milwaukee Public Schools, have to figure it out for themselves. And you can imagine, while I represent children with disabilities and their parents and the impact on school reopening, school closures for them, if you're a school district attorney advising school districts, I mean, it might be good for business in terms of all the consulting that you get, but you're essentially on your own, and you're on your own in an unprecedented and very difficult time, and that's what everyone involved in the education arena is dealing with right now.
Okay. Well, and specifically for, I know I've read about how virtual learning may disproportionately impact low-income students or students with disabilities. Is that a concern? What kind of legal issues are you going to see there?
Absolutely. So we'll take those separately. The clearest law is on children with disabilities, and that's true in education law, period, both pre and post pandemic. We have a federal law known as the IDEA, Individuals with Disabilities Education Act, and every state has to have its own special ed law. Wisconsin's, by the way, preceded the federal law back in the early 70s. And so when you hear federal mandate, well, you know what? Wisconsin came first. So it's not really a federal mandate. And that's a good thing, right? Those laws remain unchanged. There have been no waivers. There have been no amendments. The latest I'm following in Congress, both the bills that have already passed and the bills that are being considered, while there have been some discussion about waivers or amendments to the IDEA, I don't think they're in any of the bills that are currently up before the Senate. So that poses a very interesting and difficult both educational and legal question. Children with disabilities are entitled, in a nutshell, to a free, appropriate public education that is enshrined, if you will, in their IEPs, their individualized education programs. Well, let's go back to before schools closed in March. Every child with a disability that qualified for special education had an IEP. That was basically their roadmap of what kind of education they were to receive, what specialized services, what accommodations, et cetera, et cetera. And we'll cover some of that in the upcoming webinar. How do you mesh that with the fact that initially we had an absolute order from the state to close schools? It's not safe. Close buildings. They were closed and remain closed by state law. Even, by the way, the Supreme Court opinion, the Wisconsin Supreme Court opinion that said the governor did not have authority to issue the decision he did on various building closures, et cetera, did not touch the school closure. The Supreme Court did not touch that. So school buildings remained by state order closed until June 30th under state order. There is, as far as I know, no further order on that, but there may be. We'll see. How does that impact? We're certainly going to discuss it, but I'll tell you, there are some things like how do you do physical therapy, for example, when the school buildings close? Of course, most school districts are trying to do the best they can, trying to do things online. Some things, whether it's instruction or let's say something like speech therapy, actually can be done online. And our entire society, frankly, the whole world is learning of new tools, just like we're doing right now in Zoom, things that may in some cases even work better. That's fine. But in other instances, it's just not working. Now, the practical reality, I don't think there's any, how shall I put this politely, caring, thinking person who says, well, just they have an IEP, let's put them back in school regardless of the health consequences. That being said, what do we do about the fact that for, I'm sure, thousands and probably tens of thousands of children with disabilities, not only are they not getting a very good education in general during this period, and probably in the beginning of the school year, we don't know how long the pandemic will go, but they're simply not having their IEPs complied with. There is a short answer. I'll give the longer answer during the webinar. There is a provision in the law called that entitles them to what's called compensatory education. In other words, when this is all over, my prediction is that you will see many, many claims, and this is where the lawyering will come in, for compensatory education to make up for what they lost. Okay, and we'll certainly talk about that in the webinar. As far as the other things like, the more severe impact on low-income children, children from, say, Black, Latino children, et cetera. The law isn't as clear on that, but there's no doubt there's an impact. It isn't as clear because they don't have the same kind of rights unless they also happen to be children with disabilities with an IEP. But that's where my fellow speaker at the webinar, McKenna Kohlenberg, who, though she's a law student, is frankly one of the most brilliant law students that I've had the chance to work with in my 35 years. She's also getting a dual degree of master's in education law and policy. She wrote a law review article on the right to read. Before, in fact, there was a single appellate decision on any such right. I helped her in terms of reviewing it. And it turns out she accurately predicted a recent Sixth Circuit decision in Gary B. versus Snyder that basically said, in order to be an effective citizen, including cast your vote, you have to be able to read. And this case was against the Detroit Public School District and the state of Michigan, where there were severe problems with, thousands and thousands of children in Detroit who simply couldn't read. And the court established, the Sixth Circuit established a constitutional right to read. It obviously doesn't apply directly in Wisconsin, but I'll tell you, if you're a school district attorney or an attorney representing children, you ought to be thinking about, is there a claim here? Has that claim actually been, it may have existed in certain school districts or for certain students before the pandemic, just as the pandemic is exacerbating many, many social, educational, health issues, it may be exacerbating that one too. But it being it right now during the pandemic, probably not. But after the pandemic hopefully is over, hopefully sooner rather than later, will there be potentially viable claims based on that Sixth Circuit decision? I think so. And McKenna will be the lead speaker on that.
Okay. Wow. A lot to think about, Jeff. And I know you're going to be covering a lot more in the program again, August 25th. We'll certainly let people know about that. I really appreciate you coming on and taking the time to give us the lay of the land on what's going on. Should be interesting to watch.
Sure, glad to do it.